Welcome back to Court TV Live. I'm Cody Thomas. All eyes on Utah today, where a week-long preliminary hearing will tell us what to expect from the murder trial of Tyler Robinson. Now, he's the man charged with aggravated murder in the shooting death of conservative activist Charlie Kirk. Now, this preliminary hearing will serve as a preview of the state's case, with prosecutors laying out their evidence. Now, Kirk was shot during a campus event at Utah Valley University last September, and his widow, Erica Kirk, is in attendance today. She and the defendant are off camera, but the judge did acknowledge them both this morning.
Good morning. Mr. Robinson, good morning. For the record, the court also recognizes the presence of Ms. Erica Kirk. Ms. Kirk, good morning.
Now, the prosecution is laying out its case during this preliminary hearing, so let's get back inside where an officer is still on the stand.
I need to view this again, so let's just put it on my monitor. Again, I'm just trying to make sure that in order for make a ruling on this, I need to view it. So let's put it on my monitor, play it without any sound. Okay, my understanding is the prosecution has control of this exhibit, so what I'm asking is that the sound be turned off, if there is any, and just go ahead and play it, and it's only on, well, it's on all the parties' monitors, because I want you all to view it, because that can go directly to, as you've mentioned, Ms. Nestor, whether it's possibly admissible. So let's go ahead and play that. All right, thank you. Based off what I've watched, there was some blurring of faces, but not of all the faces, and so I'm going to rule that it is admissible. Sure, I'll wait until all parties are ready to proceed. So anything further? I just want to make sure.
No, Judge, you've had a chance to watch that.
I did. So I'm ruling that it is admissible into evidence, again, taking into consideration the analysis the court's talked about in regards to 1102s and this particular piece of evidence as it relates to the 1102 video, or the 1102 statement 6.1, and I'm going to allow it to admit it into evidence. And because the faces of the alleged victims are not all obscured, there are some that are visible, it's not going to be published to in-court monitor, and obviously not to be filmed by the media. So the court will receive it into evidence. The court will watch it again right now, and then we can continue to proceed.
Very good. Thank you, Judge.
So if to the state, if you would like to play it again for me, I'm viewing it as it relates to consideration as the magistrate.
Your Honor, sounds like an issue that's going to come up again. I represent the news media. Can I be heard on this issue?
Yes.
I just wanted to address it. I've tried to be quiet. I just wanted to address it now because it's going to keep coming up, it sounds like. The classification rule that Ms. Nestor is citing and that Your Honor was just reading is not about in-court exhibits. That is classification for records in the court file. So it is a fundamentally different thing when we are in a public proceeding and the state is presenting an exhibit that you are relying on, and the public is being denied the chance to see it. That is a fundamental violation of the right of access, and it's a qualified right, and I recognize that. But that's not the ruling that you just made. You're just ruling based on the Code of Judicial Administration, which doesn't have anything to do with when something is presented in a public proceeding. So while I recognize there are certain things where I understand that you were going to make an exhibit-by-exhibit evaluation based on certain exhibits that may, be somewhat, may cross the heavy threshold of being so prejudicial that they cannot be shown in public. That is not this. And so I just wanted to make clear that the things that are in Rule 202 are not, when it is presented in open court as an exhibit for you to rely on, the public is entitled to see what you're seeing so that they can understand what your decision-making process is. And so this one, it doesn't sound like this sounds pretty anodyne to me. It's not even depicting the shooting. I just wanted to clarify that the classification issue about when, we're filing things with the court and we say like this, maybe we file a motion to classify. That's not the decision that you're making today. The decision you're making today is the state is presenting something to you. You're watching it. You're making a decision based on it. And the people in the gallery have the right to see that. Whether you allow EMC of it is a different question. And we think that the EMC should be allowed too, for reasons that we briefed. But I do think that it at least should be published to the courtroom.
Thank you.
Thank you, Your Honor.
To the parties, do you wish to respond?
State is not. We'll submit it. Well, Judge, I'm sorry.
Oh, hold on. Okay, so
I'm sorry.
we'll go to Ms. Nestor first
ahead.
and then to the state.
No, Your Honor, thank you.
Mr. Sturgill.
The only other additional observation I'd make is with regards to this video and this video only, the state doesn't believe that the defense really has standing to make an argument on behalf of the victims in this case.
All right. All right, based off of what's been presented in recognizing the argument from the media, I see the differentiation and how they are differentiating the rule that was cited versus what was presented. So I'm going to go ahead and rule that this may be played in the courtroom but not be captured on video. So to the camera operator, I just want to make sure that it's going to be playing on that, but I don't want it captured. I appreciate the patience of the parties as we were going through the many layers that need to be addressed on exhibits such as these. So we'll go ahead and, once that's ready to be played, let's go ahead and do that.
That's a lot of people, Utah, I'll tell you what.
Order. Alice?
Everybody, you know how it works.
Thank you, and that concludes Exhibit 6.
Correct. Thank you.
Mr. Sturgill, you may continue.
Agent Hull, did you or any other SBI agent collect additional video?
Yes, there were other videos collected.
What additional video did you collect?
A cell phone video from Mr. Phillips was collected.
And do you know who or how that video was collected?
Yes, Agent Schultz made contact with Mr. Phillips September 29th of 2025, and that video was provided to him. Subsequently, in preparation for the proceedings today, myself and Agent Davis met with Mr. Phillips on April 6th, and he completed an 1102 and went through the same process as Ms. Wright. The only difference being on this occasion that because he is a minor, his mother witnessed it and also signed the statement.
Okay. So you personally reviewed Mr. Phillips's video with Mr. Phillips?
Correct.
Okay. And you had him prepare a written statement?
Yes, correct.
Okay. Again, on this written statement, are there two different authors?
Yes, I believe in this instance it was myself that wrote the file name on the form.
Okay. And so you wrote, what part of the statement did you write?
Just the name of the file that we were asking Mr. Phillips to verify.
Okay. I'm going to have exhibited on your screen what's been marked State's Exhibit 7.1. And this should just be for Agent Hall.
That's on my screen.
Is it on your screen? Do you recognize what that is?
I do, yes.
What is that?
The State Bureau of Investigation 1102 form completed by Mr. Phillips.
Okay. And did you gather that from Mr. Phillips?
I did, yes.
And again, does this statement include the advisory that is going to be used in lieu of his testimony at prelim?
It does.
And does it also include a warning that if he makes the author makes a false statement, that it could be punishable by being charged with a Class A misdemeanor?
It does, yes.
Okay. Anything about this exhibit look different than the day you collected it?
No.
So the state would seek to admit Exhibit 7.1.
Ms. Nestor?
Thank you, Your Honor. We would object to the admission on the grounds that this video does, in fact, show a close-up view of the shooting of Mr. Kirk and grievous injuries in very stark relief. And because of that, we are particularly concerned about our constitutional claims we have made and our standing objection in terms of our ability to get a fair trial if this is published. And I think, again, we have the same issue with the court, being in a position where you're having to make a reliability determination without the opportunity for this individual to be cross-examined. Also, I do think the fact this is a minor that completed this form does make it protected. He's also potentially a victim under the same theory that has been stated for Ms. Wright, and under the UCJA acts for the same reason, the UCJA rules for the same reason, these should be protected private court records, and private means it shouldn't be played to court and it shouldn't be played to the public through.
All right, let's bring in our guest this hour. Still with us, criminal defense attorney Silva Megerditchian, and now joining us, former law enforcement officer and domestic violence expert Claudia King. Silva, you got to understand, me and Claudia usually, match colors, and today she chose these Florida Gators, blue and orange, against my will. So I just had to put that out there, everyone. But Silva, we'll start with you. We'll see Claudia shaking her head. Silva, we'll start with you. This hearing here seems to be getting a little contentious right now as far as exhibits needing to be admitted. Seems like the defense wants to keep some video out from the public. What are you making of all this contention here?
Oh, Cody. First of all, hi, Claudia. Always honored to be with you. Listen, Cody, this all makes sense because you have to think about it. A preliminary hearing that is televised, everybody who's watching is a potential juror, right? And when you're talking about Utah and how concentrated Utah is and how high profile this case is, the defense wants to make sure, as much as they have power over it, they want a fair and neutral jury. And it's very hard to have a fair and neutral jury when you have this type of videos coming out with the public seeing it. And let's not forget, Cody, there were over 3,000 people at this event. So all of that video, all of that audio, all of these disturbing images could really turn a potential juror who might be neutral at the start into having thoughts of what, preconceived notions and not being open to hearing all of the evidence in trial. So in this case, the defense is really trying to do their job to keep a neutral jury involved.
Yes, it all makes sense. And Claudia, I know you have your law enforcement expertise here, and I just want to talk to you about some of that. You've been in these high tension moments and moments that, get the heart pumping here. Talk to me about, situations like this. What are the protocols? How fast people jump into action? Talk to me about your experience with that, as far as the actual shooting that took place in Utah.
Absolutely. And first, I want to say I would never choose the Florida Gator colors. So let's just leave it at that. Anyway, So, situations like this, we train really heavily for because you have to act so quickly. And what I really want people to understand is that ending the threat always comes first. And so you will often see law enforcement stepping over victims trying to get to the threat because paramedics, EMTs, they can't come in until the scene is made safe. So you have to remember as a law enforcement officer, like there's somebody there that might need my help, but first I have to take care of what is threatening the situation. So it's definitely a high adrenaline, high stress situation. You got to just keep your cool, move forward, make sure that threat is handled, and then move to taking care of the victims.
Absolutely. You know, Silva, we've been talking about it in previous segments here today. You know, this is shaping up during this hearing to be one of those situations where no singular piece of evidence by itself alone needs to be, you know, overly impactful just because of the sheer cumulativeness of everything the prosecution is going to present, not only today, but over the next 5 days.
Yeah. It's overwhelming, Cody, isn't it? Because already we have so much, and so much of it has already been made public. So you wonder if this is Monday, what's Tuesday through Friday going to bring for 5 days, right? Will it be such overkill that, again, the defense is going to kind of have a little bit of an advantage to see everything that the prosecution is going to set forward? It's a really easy case for the prosecution. And again, Cody, it's like we said before, it just feels like maybe they are putting so much out there that it is unnecessary at this stage. Probable cause in this case can be shown, I would say, in a couple of days. I think 5 might be very excessive.
It's almost like they're putting so much out there, but it keeps you wondering how much they still have, because I'd imagine they don't want to put every single last thing out there in a week, but you know, you never know. I digress. But my friends, stand by. Silva and Claudia, stand by, my friends. We're going to keep it right here in Utah after this short break. Folks, keep it right here on your front row seat to justice.